we'll proceed then. We're here on the government's motion for stay pending appeal. I'd note that we have and maybe counsel for the government can just address this when it's his turn to speak. We understand that you're invoking Rule 27-1 sub 3 as opposed to 27-3. In other words, not an emergency motion, but you have requested an expedited hearing, and a special panel has been drawn by the chief judge for that reason. What we don't know, because the briefing doesn't tell us, is there a specific reason that the ruling is requested by August 4? With that, I don't have any other questions that I wanted to highlight up front, and we're ready to hear your argument.
Thank you, Your Honor. May it please the court, Yaakov Roth on behalf of defendants. I'm hoping to reserve about 3 minutes for rebuttal. I'll watch the clock for that purpose. Just to start with Your Honor's question, no, there's no particular magic about August 4th. We were trying to just be reasonable about, the money is being drawn down every day. So it's a situation where we view it as irreparable harm, but because we took a little bit longer to move, we didn't want to jam up the court or opposing counsel. So we tried to pick something that was a reasonable date in light of that.
Thank you for that clarification.
So, Your Honors, we are asking the court to stay the injunction because it rests on errors of law and because the balance of harms favors a stay. And the district court found that plaintiffs were likely to succeed on 3 claims: a First Amendment claim, a statutory claim limited to the NEH, and an APA arbitrary and capricious claim. And I'd like to walk through each of those and explain why we think the district court was wrong as to each of them. With respect to the First Amendment, the district court misunderstood the controlling principle of law. The government generally gets to decide what it wants to pay for and what it does not want to pay for. And that alone is not a First Amendment violation. Now, what the government cannot do is use those subsidies to try to coerce or suppress speech outside the context of the funded program. And the Supreme Court explained this dichotomy in the USAID case back in 2013. The government can say, we only want to pay for X, we don't want to pay for Y. The government cannot say, we're not going to give you money for X if you say Y, that's unrelated to the program we're paying for. But respectfully, we are on the constitutional side of that line here. All that happened in this case is that these agencies decided they did not want to pay for research on particular topics going forward and therefore terminated grants related to those topics. That alone.
I have a question here, counsel. Forgive me for interrupting, but I have a question that goes right to this point.
Great.
So if I could, the McDonald Declaration at paragraph 20 says the NEH's authorizing statute does not set forth any prohibition or limitation on the sole discretion of NEH chairperson to terminate or rescind grants. I'm not aware of any such limitation in the law or the regulation. So, of course, my question has to do with, is it the government's contention that these grants could have been terminated on the basis of viewpoint?
It depends a little bit on what Your Honor means by viewpoint. So I do think the government can say, we want to pay for research supporting Proposition A, and we don't want to fund research supporting Proposition not A. I do think that type of discrimination is permissible when all we're talking about is the government's own funding of the speech. What the government could not do is say, for example, we saw that so-and-so, you have a grant to do research on, cancer, but we noticed that you were outside protesting against the president last week, so we're going to pull that grant. That would be leveraging the subsidy for a First Amendment problematic reason, and that would run afoul, I think, of principles articulated in the USAID case and other Supreme Court precedent. But we don't have anything like that here. All we have is the agencies have decided these are topics they don't want to pay for anymore. They don't want research on these topics. Maybe a good decision, maybe a bad decision, but it's not a First Amendment violation to make that decision.
Can I just, if I could follow up on that, you're viewing these keyword searches as necessarily identifying programs? In other words, it strikes me that DEI could be viewed as a programmatic label and description of a content. It also, opposing counsel certainly argues that it is necessarily directional and it expresses a viewpoint. Do you draw that distinction?
I view it as more akin to content than viewpoint, but I also don't think it legally matters. We give the example in the brief, for example, of, if the government says we want to fund speech that's in favor, against drug use, we don't have to fund speech that's in favor of drug use. The government is allowed to have a viewpoint, and the government is allowed to say, we're going to support programs and grants that align with the government's viewpoint. Again, that, as long as it's limited to here's what we're going to pay for, here's what we're not going to pay for, relating to the actual program or grant at issue, that does not pose a First Amendment violation.
Does it make a difference? Counsel, as to the timing of the decision by the government? So, for example, I hear you when you're talking about sort of the government's decision-making authority in the grant-making process. So we have cases that clearly say when you are the government is deciding to make a grant in the first instance, has broad discretion to decide what to fund and not fund. Is there any difference if there is a decision to terminate a grant mid-grant cycle, not even during a renewal, but just as it was done in this case?
So, Your Honor, I don't think there would be a First Amendment difference between those things. I think if there's a difference between those two, it could relate to the grant terms and whether it's consistent with the contract. So it may be that the government is not entitled to terminate a grant midstream. That would be a contract breach claim against the government. But from a First Amendment standpoint, I don't view there as being any principal distinction between a decision at the outset that we don't want to pay for this and a decision to...
But here, okay, so I understand what you're saying. Here, I think the plaintiffs are arguing the fact that this occurred so closely in time and in direct reference to the executive order relating to very specific viewpoints, the dangerous, quote unquote, dangerous ideas that are referenced in the DEI executive order. Doesn't that sort of bring the timing and the viewpoint sort of together to say that this was in fact discrimination based on a particular viewpoint or content of the grants?
So, Your Honor, we don't contest that the decision-making was triggered by and certainly informed by the executive orders. We just don't think there's any First Amendment problem with that. The executive orders represent the administration and the president's views about what should be, what the policies of the agency should be and what the priorities of the agencies should be and the types of programs they should and should not be funding. And the First Amendment doesn't limit the government's ability to decide, we don't want to pay for this project about Mark Twain anymore. We'd rather spend it on something else, as long as it's consistent with the statute and any other applicable sources of law. But the First Amendment itself doesn't prohibit that. That's the Finley case from the Supreme Court, Rust and Regan. And we think that the district court misunderstood that key distinction.
Mr. Roth,
following up.
Hold on.
Sorry.
Let me just ask a question, Judge Kristen, then we can move on. But I just have one question about this. Is it your view that there's nothing expressive in the grant application?
No, I don't think we're taking that position. I don't think we need to take the position that it's not expressive. It's just that the government's decision whether to fund it or not fund it is not punishing the speech in a constitutionally prescribed way. That's the government's decision about how to spend its money. And as long as
let me ask you, didn't the government make that decision at the outset when it approved the application?
Yes, absolutely. The government made the decision at the outset, we want to pay for this. And then
they've been if you take the Kapoor or Thakur, her application, it was funded over 2.5 years ago.
That's right. So the government made a decision, we want to pay for this. And then the government changed its mind and said, we no longer want to pay for this going forward. There was no clawback of the old money. It was just going forward, keep paying for this.
But as Judge Desai, as Judge Christian was indicating, I mean, you seem to have taken this action based on the viewpoint that is expressed in the application, and you put the thumb on that and said, we don't want to fund this anymore.
Right. So I guess what I would say, Judge Paez, is if at the outset the government was free to say, we read your grant application, we like this idea, we want to pay for it. I don't see why the First Amendment then prohibits the government, when there's been a change of administration, from saying, we took a look at it, we don't like this anymore, and we don't want to pay for it, so we're not going to keep paying for it. If you can do one, I'm not sure why you can't do the other. Again,
but counsel, that's because you're viewing, I think, I just want to push back on this to follow up on Judge Paez's question. In your question, under the Russ versus Sullivan line of cases, is an entire program. And I think that's very well established, and you've briefed that really well. But what we're trying to explore is whether or not it is the government's position that the word searches or the way these grants were terminated may also be reflective of viewpoint discrimination. So the problem is, for me, is that there's a distinction between DEI as a program and DEI as a viewpoint. And if we just look at the dictionary definition, right, that tells us that DEI is used in a way that is necessarily directional. It is a general view that our history of discrimination and exclusion of certain classes is undesirable and ought not continue. So if you just take that from the dictionary as a premise that there's a difference between a program and a view, I'm not sure how Russ versus Sullivan helps you.
Well, again, Your Honor, let's accept the premise of Your Honor's question that it is a viewpoint that we're talking about here. That means when the government decided to pay for these grants a number of years ago, they were saying, we like this viewpoint. We want to support it with our government money. So here's some funds to advance your project because we like the viewpoint. Now the government's position has changed, and the government's position is, we don't think this is a good use of government money, so we no longer want to pay for it. The viewpoint, one way or the other, does not restrict the government from making funding decisions. I think that is clear from Finley, that you can take into account content, you can take into account viewpoint. The government doesn't have to fund both sides of the debate equally, as long as it's using its own funds and it's not trying to go beyond the scope of whatever the thing is that is being paid for. Here are these grant applications.
I'm going to pivot a little bit because I think this is a very interesting case, and the First Amendment issue certainly is. But if we could pivot a bit to Judge Desai's question, going back to what difference does it make that these were made midpoint, and Judge Paez's example is, I think, a very good one. Dr. Thakur's research, she's within, I think it's a 3-year grant, and she was within a few months of concluding it. For the purposes of the APA, the Supreme Court has been very clear, I think, that reliance interests have to be taken into account. So what about that? Is there evidence in the record that reliance interests were taken into account?
No, there's no specific evidence of that. And so let me address the APA claim, because Your Honor's question goes directly to the APA claim. And our position on the APA claim is really quite simple, which is that the APA does not allow claims that a breach or termination of a contract was arbitrary and capricious, because those are disguised contract claims that must be brought in the Court of Federal Claims, and therefore APA relief on those claims is impliedly precluded. We think the Supreme Court stay order in Department of Education is controlling on that point. And I know it was not.
I have a question on this, because I think there is a critical distinction, and I think the plaintiffs point this out, which is that in Department of Ed, the plaintiffs were parties to the contract, and here the plaintiffs are not parties to the contract. And so how can they bring a contract-based claim if they are not parties to the contract?
Thank you. That is absolutely a distinction, Your Honor. I was trying to peel apart the two questions, because I think it's analytically, I think there's two separate questions. Is it the type of claim that is a disguised contract claim that is subject to the implied preclusion? And then if yes, so in other words, if the University of California could not bring this claim in federal court, it would have to go to the claims court. Does it matter that the plaintiffs here are not parties to the contract and therefore might not be able to go to the claims court for relief? So I was hoping to take them in that order, but I'm happy to jump to the second one and say, assuming that the University of California could not bring this claim here under the logic of the Department of Education, we don't think it makes any difference that these plaintiffs are not able to seek relief in the claims court, because being a step further removed from the contractual relationship doesn't mean you get additional rights or that these APA rights spring back into force.
Yeah, so you make this argument in your motion, your stay motion, I think it's at page 15, where you say that they have these additional rights, that this proceeding, allowing these plaintiffs to proceed with their claims here would give them greater rights than parties to contracts would have. But I'm not sure I really understand that, because parties or non-parties can bring claims in federal court based on statutory or constitutional claims that they have, but parties to a contract have the additional ability to bring claims in the federal claims court. So I'm not understanding your argument that this somehow gives them greater rights when in fact they are limited in what they can bring in terms of contract-based claims in the federal claims court.
Your Honor, here's how we see it. The way we see it, the Tucker Act creates a regime for contract claims with the federal government. And it has limitations. So not everybody can file a claim. And there are certain remedies you can't get in the claims court. And there are all sorts of other restrictions. The consequence of that scheme, though, is that the APA impliedly precludes relief that you could get or could not get on those claims in the claims court. And so, for example, you can't get an injunction in claims court. And so parties have come to federal court and said, well, I only want an injunction. I can't get that in claims court. I should be able to get it here. This court expressly rejected that argument in North Star, Alaska. It said, no, the fact that you can't get that relief in claims court means it's impliedly precluded under the APA. You can't come here and get it either. And so I think it's exactly the same dynamic with respect to the party principle. If the rule in claims court is you've got to be in privity with the contract to sue. And by the way, there are exceptions to that.
Counsel, the rules you're talking about are all premised on the assumption that this is a contract claim. Right? They'd have to be, I think what you're arguing is that they'd have to be a party to the contract or a third-party beneficiary if they were bringing a contract claim. But Judge Desai's point, they're not bringing a contract claim. They're bringing claims for, this class is bringing a claim to pursue the right to be free from arbitrary and capricious agency action.
Right. So that takes us back to the first question, the predicate question. Are these really disguised contract claims?
Why do you think they are?
So let me give you 3 reasons why I think they are, Your Honor. Number one, it's exactly the same claims as were at issue in Department of Education. Those were grant termination.
Well, in Department of Education, I think I agree with Judge Desai that is distinguishable, sir, because in Department of Education, the Supreme Court talked about the relief granted by the district court in that case, which included payments past due on the contract. The court was enforcing the contract. That's not what these folks are looking for here.
Your Honor, if you look at Department of Education, if you look at the district court and the First Circuit decision in that case, it was exactly the same. They were saying these terminations of grants are arbitrary and capricious. We want an injunction to restore the grants going forward. That's what the district court granted. That's what the First Circuit said was permissible. And the Supreme Court said, no, the government is likely to succeed on its jurisdictional objection that this is really a contract claim that has to be brought in.
Sir, I'm trying to call your attention to what the Supreme Court told us, and you're not responding to that, if you could, please. The Supreme Court referred to the type of relief entered by the court, by the lower court. And that included payments for past dues. Forgive me, I didn't mean to talk over you. That included payments past due under the contract. Can you help me sort that out?
Your Honor, it was both. So it was the same dynamic as here. The contract, the grants were terminated, and they said, bring back the grants. And that means you've got to pay for whatever, the last 3 weeks and going forward indefinitely. And that was the relief that they got there. And that was the relief that was requested here, an injunction to restore the grants, to nullify the termination of the grants. So
Counsel, I will grant you that the language in the Supreme Court decision, Department of Education, may be broad enough to include what you're arguing. I think the difficulty here is that there's very little reasoning. And so we're having to interpret what the Supreme Court has said in this case, which is all one line that says the Tucker Act grants the Court of Federal Claims jurisdiction over suits based on any express or implied contract with the United States. And that's all it says. And I understand your argument, but if we're trying to interpret what that means, and we know that in that case, the parties were in fact parties to the contract, and here they're not. Why is that distinction not one that is important to make, especially because if we agree with your argument, there is no way that these plaintiffs can seek the relief that they're asking for?
So I do think that distinction can be drawn, Your Honor, and that's my prior answer to your earlier question that about how the limitations on who can sue in the claims court should be viewed as impliedly precluding, the same way the limitations on remedies in the claim court should be construed as impliedly precluding broader APA relief. But this is why I want to say.
Forgive me. Can I just clarify? That's a little different than what I thought you were arguing. But I just asked you straight out: is it the government's position that these claims could be brought in the Court of Federal Claims?
They can bring them. They might lose, and I haven't fully analyzed that because it's complicated.
That's a nice lawyer's way of saying they can't bring them.
Well, I just don't see a path, counsel. And this is your opportunity. If I'm missing it, I don't see a path. How could they do that?
Oh, well, the claims court, this is all sort of case law in the federal circuit and the claims court about when non-parties can sue. And there are limited situations. I'm not saying they can here. I don't want to make that representation. I think probably they can't.
I think your argument is that the universities who are the contracting parties can bring the claim. And because there is somebody out there in the universe who can bring these claims, that's sufficient.
Correct. The universities definitely, as the counterparties, can bring a claim premised on the breach or termination of the contract in the claims court. And there's certain, again, they may win or lose, and they may be entitled to one remedy or another, but that sort of takes all of this out of the traditional APA cause of action under the principles of the Department of Education. Now, I don't want to solely rely on the Supreme Court's order because I understand that it didn't have a lot of reasoning, but let me explain why I think it's entirely correct. And it's a point that the DC Circuit made in Megapulse, 40 years ago, footnote 34 of Megapulse, which is really just a simple one. If a plaintiff could evade the Tucker Act and its limitations on relief and other restrictions by recharacterizing a breach or termination of a contract as arbitrary and capricious agency action, it would completely undermine the point of having this channeling regime, because there is no breach or termination that you could not come into court and say it was also arbitrary. They're going to overlap all the time. And that's why the APA should not be viewed as conferring an independent substantive right on a party to a contract to avoid arbitrary and capricious action. It should be dictated by the contract terms. And I'd like to just offer one hypothetical, if I can, to try to illustrate the point, which is, there are many contracts that say if a party wants to terminate, use the form in Appendix B to the contract. And it might just be a form letter that says, I terminate, send it to this person. If the party did that, and the counterparty came to court and said, well, this is arbitrary and capricious. It's a form letter. There's no reasoning. There's no explanation. Of course, we would say, no, given the way this contract is written, that was perfectly reasonable way to terminate it. We wouldn't layer on top of that additional arbitrary and capricious protections from the APA. And I think what that's showing...
Can I turn you to another topic? You're running short on time, and Judge Kristen can sort of manage that. But I do have a couple of questions I want to make sure I ask you before you sit down. And this really goes to the irreparable harm arguments. So why has the government moved to stay the injunction as to the EPA and NEH grants, but not the NSF grants?
Oh, it's just because the NSF doesn't want to have interim relief. They've decided, having reinstated these contracts, they'd rather not potentially have to cancel them again and restore them again. They just want to wait till the...
Why would two of the agencies, the EPA and NEH, be irreparably harmed pending appeal, but not the NSF?
I think they're all irreparably harmed. Just only two of them want to press the point, and we're not going to bother the court with something the agency doesn't want. The irreparable harm is that the money is being spent, and that's irreparable for the same reasons as Department of Education.
Okay, so let me, to your last point here, what evidence in the record establishes that the grants will not be repaid if the federal government ultimately prevails?
Your Honor, we're not aware of any mechanism that would allow recoupment of money
So in Department of Education, this was an uncontested point. In fact, I think the plaintiffs conceded that there would be no way for the money to be repaid, and they had no intentions of doing so if the government ultimately prevailed. That's not the case here, correct?
Your Honor, here I think it's actually a fortiori because these plaintiffs aren't the ones getting the money. It's the university. It's not even a party. So we can't possibly get any representation from the university that, don't worry, we'll pay it back if we lose at the end of the case, because they're not even here.
Aren't there certain, I thought I read in the brief that there are certain procedures that have to be followed when a grant comes to an end? Like
there's closeout
audits, closeouts,
that's right,
reports.
Correct.
And I assume that if money was allegedly misspent or not properly spent, the government could make a claim for it.
Your Honor,
right?
I think, right, but I think if the court reinstates, as it did below, the court ordered reinstatement of the grants. If we win this case in a year, I don't think we're going to be able to go and say, well, all the money we paid you in the interim was wrongly spent. I mean, there was a court order in place at that time that said this grant is live. So we had an obligation to pay that money, and they were entitled to spend it.
Well, I guess at the end, if there's a judgment in favor of the government, then what happens to that argument that you just made?
Well, the final judgment would be no injunction. You know, the injunction gets dissolved going forward. But I don't think that would entitle us to recoup. Now, look, if this court wants to say that at the end of the case, we're entitled to claw back all the money from University of California if we win the case, that does solve the problem.
I haven't really looked at the regulations or the policy statements that relate to all of that, but I remember seeing something in the briefs about methods that have to be followed when grants terminate or when the government ends a grant midway.
There are, yes, Your Honor is correct. There are closeout procedures, and they allow you to, even after a grant is terminated, they allow the grantee to claim certain money for winding up the program and so on. But there's nothing in those that says, you know, if we get an injunction that requires us paying the money, we can come back and claw it back. Again, if this court wants to say otherwise, we'll be happy with that. But that's not my understanding of the law. I see I'm over time.
You are over time, but we're going to give you a little bit more. I'm not quite done. Could I just ask for clarification? Is your channeling argument limited to the form termination class?
Yes. For purposes of the stay motion, yes, we've only raised it as to the form termination class. We have not argued in this motion that the First Amendment claims are subject to the channeling.
Okay, I appreciate that clarification. If my colleagues don't have any other questions at this point, we'll hear from opposing counsel, and I'll put a few minutes on the clock for you to come back. So we took up quite a bit of your time with our questions.
Thank you, Your Honor.
You bet. Whenever you're ready.
Thank you. Good morning. May it please the court. My name is Erwin Chemerinsky, and I represent the plaintiffs. This is a case that poses a question of profound importance. Can the president cut off hundreds of millions of dollars of grants to researchers without any explanation, without any procedures, because he dislikes the ideas that are being presented? As I listened to the government, there were two important omissions. First, there was no mention of the standard of appellate review. It's clearly established that a district court's injunction should be stayed only in extraordinary circumstances when the government has a heavy burden of proof. And ultimately, to overturn a preliminary injunction requires finding of an abuse of discretion. And second, there's no mention by the government's lawyer of the irreparable harm to the plaintiffs from cutting off these grants. When the grants are cut off, research is stopped. Labs have to be closed. Postdocs and graduate students leave. Papers are not published. Damages years from now cannot remedy that injury. And in terms of the harm to the government, if the money is spent, it's spent in the way that Congress intended. And also, as Judge Pius pointed out, both under the federal statutes and under the federal regulations, if the government's entitled to the money back, there are ways to get it. There are jurisdictional issues and merits issues. I'll start with the jurisdictional issue, and that's the government's claim that there's no jurisdiction in federal court, that jurisdiction is in the Court of Claims because of the Tucker Act. This is precluded by on-point Ninth Circuit precedents. In United States Aeronautical Corporation versus the United States Air Force, 80 F 3rd at 1026, this court said that if a cause of action arises from the Constitution or a federal statute, then the federal district court has jurisdiction. This court reaffirmed this on May 14th in its decision in Community Legal Services versus the United States Department of Health and Human Services. There at 137 F 4th, at page 937 to 940, the court reaffirmed the United States Air Force case.
So
here you have.
So when the government says, well, really, what they're really doing here is just disguising all these claims, because really what they've got here is a breach of contract claim. And what they're really doing is they're trying to get payment of money. How does the argument you make with respect to the constitutional claims fit in with that or negate that?
Your Honor, when there's a constitutional claim, this court's present made clear that the district court has jurisdiction. And it's important, it goes to Judge Desai's question, in Department of Education versus California, there was no constitutional claim. In fact, in the Megapulse case that the government cites, the DC Circuit went on to say, if it's a constitutional claim or a statutory claim, the federal court has jurisdiction. And indeed, there would not be jurisdiction in any other court than the federal district court for the reasons that were pointed out. Since these individuals are not party to the contract, they can't go to the federal court of claims. If they can't go to the federal district court, they can't go anywhere. And the United States Supreme Court has been emphatic in saying that it should always be assumed that some court has jurisdiction unless Congress has clearly precluded it. Department of Education versus California is distinguishable on many grounds.
So hold on. If the plaintiffs didn't have a constitutional claim, would this case be more like Department of Education?
No, Your Honor, because there would still be a statutory claim. In terms of Department of Education, it's important to note there that the parties to the contract were before the Supreme Court. They could have gone to the Court of Claims. Here, the parties are not the plaintiffs in this suit. If you say this has to go to Court of Claims, then no court will have jurisdiction.
Also, what do you say to the government's argument that there is the possibility that the universities have the ability to bring their contract claims before the federal claims court? Why isn't that enough?
It's clear the fact that some other party might be able to bring a lawsuit isn't a basis for denying jurisdiction to a plaintiff that has standing, that has injuries here, causation, and redressability. I know of no case that says because one party might be able to bring a suit in a forum, then others are denied the remedy entirely. So if the university chooses not to bring a suit, then what you have is grave injury to these plaintiffs caused by the government that could be remedied by a favorable court decision, but no forum to hear it. And to address Judge Pius's question, in Department of Education versus California, the Supreme Court specifically said the fact that the relief would cause money to be paid doesn't in itself require that it go to the Court of Claims. And there the Supreme Court cited Bowen versus Massachusetts for that proposition.
What about the argument that opposing counsel makes that every breach of contract could be repackaged as a claim that the agency action was arbitrary and capricious?
Your Honor, there's no basis for that. There would have to be a showing in the particular instance that the agency action is arbitrary, capricious, and abuse of discretion. As I'll discuss with regard to the Administrative Procedures Act, here the Supreme Court has been very specific about what's required, and we allege, and the district court found that those are met. There's no basis for the government's assertion that every breach of contract could be recharacterized in that way. But again, I remind this court, under binding Ninth Circuit precedent, when a cause of action arises from the Constitution or a statute, and the APA is a statute, the district court has jurisdiction.
Mr.
Can we turn to the First Amendment? Forgive me, Judge Desai, go right ahead.
I have one more question on the reviewability issue. The government really doesn't address the finding that the district court made that the record is really undeveloped with respect to the EPA's the judicial review of the challenge EPA decision. And I'm curious to know your thoughts as to what we should do with an undeveloped record and sort of deciding the merits of the reviewability argument when, at least as to some of these grants, there's nothing in the record to talk about the reviewability issue.
Sure. As to the constitutional claims, there is ample evidence within the record to show that the grants were cut off, as you had indicated, precisely because of the disagreement with the ideas. And with regard to the APA claim, the fact that there's nothing in the record, that the government gave no reasons for its decision, shows exactly why it's arbitrary, capricious, and abuse of discretion.
But didn't the government argued, as I recall, that if you look at the executive orders and some of the content in the form letters, that one can discern the reasons. What do you do with that? What do we do with that?
Your Honor, this goes to the Administrative Procedures Act claim. Let me then address it first before getting to the First Amendment claim. And here it's important to remember what the standard is. It has to be that the government action is reasonable and reasonably explained.
Right.
And the Supreme Court has said if the government is going to change its policy, it has to explain the basis for it. And additionally, as Judge Kristen pointed out, the Supreme Court has been clear that reliance interests must be taken into account. And Judge Pius, when you look at the termination letters, they didn't do that. They were form letters that simply said, you're not consistent with priorities. And I think here, too, there's a Ninth Circuit case on point. The Northwest Environmental Defense Center versus Bonneville Power specifically addresses this and says, a conclusion that priorities have changed isn't sufficient to meet the requirements of the Administrative Procedures Act.
Dean Chemerinsky, there seems to me to be another layer here, and maybe you could address it. There's the executive orders. There was an admission by opposing counsel that these terminations were an attempt to execute those orders. But of course, what terminated, the termination decisions were made by the agency heads, if I'm not mistaken. And we have two declarations in the record from one agency head, Mr. McDonald's. There's this statement that he did indeed seek to, in fact, I think his first cut was a DEI word search. And a word search for other terms that came straight from the executive order. And then from EPA, it's quite to the contrary. The Daniel Coogan Declaration says that there was a grant-by-grant review process, and we looked at grant titles and project description, and specifically says that those decisions were made independent from any executive order. So it seems to me there's an inconsistency there, and certainly there's a new reason being announced that wasn't in the termination letters. The district court noted that, and then she noted that this left the public guessing. If there's a permissible reason and an impermissible reason, what do we do with that?
Your Honor, what I think is important here is that in both instances, it was based on keyword searches. And then we can talk about why that's arbitrary. With regard to the EPA, if you look at the Coogan Declaration, it's docket 43.2, paragraph 8, that says it was keyword searches. With regard to the National Endowment of the Humanities, it's the Michael McDonald Declaration, docket 46, in paragraph 9. We would argue that the keyword searches are inherently arbitrary because when you just look for a word without any context for the word, obviously you're going to make huge mistakes. Also, Your Honor, the form letters were used, and where form letters are used for termination, that fails the requirement that the decision be reasonably explained. And that's what makes this arbitrary and capricious. And to go back to your earlier question, in none of these was there accounting for the reliance interests of the grant recipients. And the United States Supreme Court made it clear in Department of Homeland Security versus Regency versus California that there has to be taken into account of the reliance interests. It's all of this that makes it arbitrary, capricious, and abuse of discretion with regard to the form termination class action.
Could you talk about another point that you made along these lines, that another problem that you argue is that it doesn't seem that in implementing that there's necessarily a connection between these particular grants and the objectives indicated in the executive order. And I'm wondering if you could give an example that would maybe illustrate what you mean there.
Sure. Take the named plaintiff in this class action suit, Dr. Thakur. She's engaged in research about the effects of fire with regard to individuals, and especially minority individuals. It's hard to see any connection between what the EPA was trying to do under the executive order and terminating these grants. And Your Honor, this also goes to irreparable harm. As her declaration points out, there are 3 papers that she wasn't able to publish because of the termination of the grants.
On the First Amendment claims, Mr. Chemerinsky, I know you're going to turn to that, but I'm just going to come out and ask you this since we're talking about this issue of keyword searches and the use of keyword searches to determine which grants to terminate. Does it hurt or help your claims that non-DEI related grants were sort of swept in and terminated by the agencies based on this sort of sloppy process that they used? Because it seems to me that for to have the First Amendment claim, you're saying that there was a viewpoint discrimination, but there's a concession that some of these grants actually don't reflect the viewpoint or content that you're claiming was censored or discriminated against. So what do we do with the fact that there may be, for example, a grant relating to biodiversity that has nothing to do with this dangerous ideas or notions that are in the executive order, but because there was a sloppy word search used, the grants were terminated?
Your Honor, that shows exactly why we should prevail, why the district court should be affirmed with regard to the APA claim. Because what you've just described is truly arbitrary and capricious decision-making. Now, with regard to those that were terminated on the basis of the content, there you have viewpoint discrimination. And the failure of the government is in characterizing the issue. The issue is, can the president terminate spending that's been appropriated by Congress because the president disfavors an idea? And what I think is very important is the government cites to not a single case that involved the president terminating funds appropriated by Congress because the president disagreeing with an idea. Every case they cite involves Congress passing a statute, create a program, either have government speech or to fund private speakers. That's quite different than this situation. And if you look at the language from the cases that they cite and from the Ninth Circuit, you see the flaw in their argument. The government lawyer quotes NEA versus Finley. But if you look at 524 U.S. and 587, the Supreme Court says, quote, the government cannot leverage its power towards subsidies into a penalty on disapproved. Cites in its brief Reagan versus taxation with representation.
I think we're losing.
Hold on. Dean Chemerinsky, could I ask you to pause where you're breaking up? And I just want to make sure that we've got.
I'm sorry.
We don't. Well, it's not your fault. I just want to make. Can everyone?
I can hear you now.
I think you're fine, but you need to kind of roll back about a minute in your argument because I've lost a bit.
Okay. Just to be clear, my initial answer to Judge Desai was that it shows how arbitrary and capricious the government decision-making is, that they were using keywords and brought in all of these grants that weren't about diversity. With regard to the diversity claim, the key point is that the government mischaracterizes the issue. The issue here is whether the president can cut off grants that have been appropriated by Congress because the president disagrees with an idea. There is no case that the government cites, and there is none, that gave the president that authority. All the cases they cite involve, Judge Kristen, as you pointed out, Congress creating a program, either as a government speak or to fund private messages. None involve this situation. And in fact, if you look at the cases that the government cites, they very much support exactly our position. Look, for example, at NEA versus Finley, which the government quotes and relies on. If you look at 524 U.S. and 587, it says, quote, the government cannot leverage its power towards subsidies into a penalty on disapproved viewpoints. But look at Reagan versus taxation with representation, which the government cites in its brief. If you look at 461 U.S. and 548, this case would be different if Congress were to discriminate invidiously in its subsidies in such a way as to aim at the suppression of dangerous ideas. Now I would go to
Dean Chemerinsky, does the enabling statute prohibit NEH from canceling any DEI-related grant?
I'm sorry, Your Honor, I didn't hear the question.
Does the enabling statute prohibit NEH from canceling any DEI-related grant? I think your argument is that the DEI or the enabling statute requires, does not, because it talks about sort of diversity as a premise or priority or principle of these grants, that by usurping that authority and in fact terminating these grants because they relate to DEI, that's improper. But my question is, does the enabling statute mean that they can't cancel that NEH can't cancel any DEI-related grant?
The statute doesn't empower the president to cancel grants. More important, I think, direct answer to your question, if you look at 20 United States Code, section 956 sub A, it specifically requires the National Endowment of the Humanities to consider diversity in awarding grants. So in this instance, with the president...
But Dean Chemerinsky, on this point, I think things are getting conflated here because Judge Desai is asking about the types of programs that they do or do not have to fund. And the provision you're speaking to is a directive from Congress that when they decide which grants are going to be given, right, then they are it uses the word shall consider, basically DEI is my paraphrase. But what about the question really goes to, are they required to fund everything that's in the drop-down list that the director is authorized to fund, or would they be permitted to terminate any one of those subject matters?
Now I understand the question better. Of course, the government can terminate grants for non-performance. And of course, the government in awarding grants can choose among them of what they believe best fulfills the statutory goal. But what's different here is the president is terminating grants in violation of the statutory goal. And here I would quote something that Judge Desai referred to, and it comes from 90 Federal Register 863. This is where the president stated the goal. It is, quote, to combat, and quote, end, quote, the dangerous, demeaning, and immoral DEI speech. That is targeting disfavored viewpoints. And that's exactly what the Supreme Court said in NEA versus Finley or in Regan versus Taxation Legislation Congress can't do. And I'd also mention, it hasn't come up yet, this court's decision in Koala versus Cosa. And here I direct you to 931 F3rd at 898. This court said, the government can violate the First Amendment by withholding benefits with censorious purpose. And that's why the district court rightly concluded here that this is a quintessential example of viewpoint discrimination.
Can I follow up on those cases, please? You invoke Rosenberger and a whole line of cases that stand for the proposition. There's a lot of cases that stand for the proposition that if the government chooses to subsidize speech, including Finley, by the way, but if the government chooses to open a forum, then they cannot discriminate on the basis of viewpoint. And I don't hear the government pushing back on that. It did seem to me, though, that you're relying on some older cases, Finley in particular, both sides cite Finley, and Regan, certainly for this idea. And so I want to call your attention to something the government raised, which is, I think what opposing counsel argues is that those many cases that have to do with limited public forum, I think he's setting aside because the plaintiffs haven't argued a limited public forum here. It's a different rubric, I think, and it is notable. And I wonder about, you're going all the way back to Finley. I'm not saying these are outdated concepts because the general idea about not discriminating against viewpoints certainly flows through Rosenberger and on to present day. But to the extent that you're relying on Regan and Finley, and I think those predate this framework. So my question is, why is it the plaintiffs haven't advanced a limited public forum, and what's the appropriate framework that the district court was to have used here?
Your Honor, I'll go back to what I said a moment ago, and that's that Congress can create a program where Congress has the government speaking, or Congress can fund private speech in a particular direction. That's what the Supreme Court said in Legal Service Corporation versus Velasquez. This involves the question, can the president terminate grants because the president wants to censor a particular viewpoint? And that has been disfavored. This court disfavors in the Koala versus Cosa case. And there is nothing since NEA versus Finley, nothing since Regan versus Taxation Representation that has ever called that into question.
I agree. I don't think there is, but I do think it's notable. And I'm not sure if this is what the government meant, but it seems to me that he's setting aside, opposing counsel will have a chance to speak to this, but that he's setting aside quite a long line of case law because the plaintiffs haven't expressly argued a limited public forum. I don't know if you think that matters, and I'm not sure why you didn't argue a limited public forum, but could you fill us in here on your view of this?
It wouldn't add anything. It wouldn't change the result. The Supreme Court has said for a limited public forum, the government can't engage in viewpoint discrimination. The Supreme Court said that in Christian Legal Society versus Martinez. The Supreme Court said it earlier in Perry Educational Association versus Perry Labor. So if you wish to characterize the funding as a limited public forum, you still get to the government has to be viewpoint neutral. And here the government is being anything but viewpoint neutral. So yes, we could advance that as the framework, but it would get you to the exact same place and the same conclusion. And
forgive me for interrupting. Go right ahead.
Please.
Well, this goes back to whether this is viewpoint discrimination. And so I look at DEI and I see some daylight. I'm not sure if I'm right to do this. I've asked both lawyers this question. Is there daylight between DEI as a program? Could the government say, we're not going to fund DEI program officers anymore, as an example, and DEI used more broadly as it is used in the executive orders? And I go to the dictionary definitions, and it seems to me that DEI is known as and is used as an inherently directional idea because it's diversity, equity, and inclusion, and it is defined by Webster's. As I indicated earlier, and I can paraphrase now, is that it recognizes a group of people who have been historically excluded, and the viewpoint is that is unfortunate and ought to be stopped, basically. And I don't know if you see any daylight between DEI as a viewpoint and DEI as a program.
Yes, of course, there's that possible daylight. But given what I read to you from the Federal Register, that the goal of the government is to end, quote, demeaning and immoral DEI speech. It's the government that has put this in the speech context by its very own words. And it's the government that's blurring the distinction between DEI speech and DEI programs by, as Judge Desai pointed out, just randomly cutting off anything that uses certain keywords. It is about
right. So doesn't that go to not to the executive orders by the president so much, but how they were implemented? Because it seems to me that it's the implementation that terminated these grants. And you're referring to internal documents that really at the agency level that reflect this viewpoint. I think I interrupted you again. I'm sorry, but could you go to, should we be looking to the executive orders or should we be looking at the agency level?
You should be looking at both, Your Honor, because the government lawyer said to you earlier in this argument that the agency actions were to implement President Trump's executive order. And indeed, when you look at what the agency did, cutting off anything that used words like diversity, it was all about trying to eliminate an idea and a message. And so the distinction that could exist in theory between the program and the speech isn't followed by the president or by the agencies, which were carrying out what the president was doing.
For the EPA, at the agency level, there is... Excuse me? I think you're frozen. Oh, we can hear you now.
I can hear you. Were you able to hear my answer to your question?
I'm sorry. Could you repeat that?
Sure. Were you able to hear my answer to your question?
I could hear your answer to my question. Could my colleagues?
Yes.
Yes.
Okay.
Judge Desai?
I don't have anything right now, Judge Kristen. Thank you.
Okay. Were you able to hear
Yes.
Dean Chemerinsky's answer? Okay. I think we're all caught up.
Okay. I'll simply conclude by saying, Your Honor, that when you balance the equities in this case, as I said at the outset, There is tremendous irreparable injury to the researchers whose grants are cut off. And with regard to the federal government, this is spending money as Congress specifically intended. And if the federal government doesn't get the money back, there are statutes and regulations that allow it to do so.
Thank you for your argument.
Thank you.
We're going to put a couple more minutes, please, 2 more minutes on the clock for the government to respond, because we took up some of your time with our many questions.
I appreciate that, Your Honor. Why don't I start with the balance of harms, because that's where counsel left off. I think the balance of harms here is controlled by Department of Education. It's the same weighing. If they win at the end of the case, they can get the money. If we win at the end of the case, we don't think we can get the money back, and I don't think they can promise that we can get the money back. I'm not saying there's no harm to them in the meanwhile. I'm sure there is, just as there was to the schools in Department of Education who weren't getting their funds. But at the end of the day, they can get the money and we can't get the money later. And they say, oh,
could I ask you on this point, isn't there a countervailing public harm when we get to the last kin factor about interrupted, because the public has invested hundreds of millions of dollars in some of these grants. And the question I think the district court grappled with is some of it could be wasted if they're interrupted now. How do we balance that at the irreparable harm stage?
I think, Your Honor, the balance is broken by the executive prerogative to decide how to spend federal money. And counsel said, well, it's no harm to the government because Congress said to spend the money. Yes, but the executive gets to decide on what to spend the money. That is the discretion that the statutes give the executive branch, and that is the discretion that is being taken away from us by this order like it was in the Department of Education. So that's the balance of harms. On the First Amendment, I'll just say I agree with Judge Christian with your question. Yes, in a limited public forum, there are limits on viewpoint discrimination. They did not argue that this was a limited public forum. The district court did not find this was a limited public forum, and that's because it's not a limited public forum. A limited public forum is when the government invites everyone in to speak and then tries to selectively pull it back for certain viewpoints. But it's pretty well established that when you have a selective program like this, where the government is always reviewing the content of the grants before it makes any decisions about what to fund, that is not a public forum. That is the government deciding what to support and what not to support.
I'm going to ask you then to speak to Finley because you invoke it, and
Yes.
to Regan, which predate the sort of the rubric of a limited public forum. Finley says, and it's been cited by both parties, even in the provision of subsidies, the government may not aim at the suppression of dangerous ideas. It also says the First Amendment clearly applies in the federal subsidy context, and if a study were manipulated to have a coercive effect, relief may be appropriate. Could you please speak to that? Because though that case and Regan, upon which it relies, does not rely upon a limited public forum context. And I want to make sure I get the government's response to this, please.
Yeah, absolutely right, Your Honor. I understand that language to refer to the situation that the Supreme Court later addressed in USAID, where you are leveraging your subsidies or grants to influence speech outside the context of the program. That is the type of suppression. You're using the subsidy to not to just support what you want to support and not support what you don't, but to influence what the people do on their own time and dime. That you cannot do under USAID, and I think that's the type of censorship that the Supreme Court was alluding to in the earlier cases. It was dicta on the earlier cases, but USAID actually is the most recent Supreme Court authority that draws this line, and I think we're clearly on the right side of it. I'd like to say a word about the APA issues.
You're way over time at this point, so please wrap up quickly.
Okay, I'll try to be very brief, Your Honor. Counsel invoked community legal services. The difference between this case and community legal services is that there, the plaintiffs were saying they had statutory and regulatory rights to have this program funded. There was independent of the contract. They said they had particular rights under statute and regulation. Here, we have not made the Tucker Act argument with respect to the First Amendment claim. We are making it with respect to the APA arbitrary and capricious claim, which does not confer an independent substantive right. If it did, it would completely swallow the rule, and it would not explain Department of Education versus California, which counsel was not able to distinguish. Aside from the privity point, which I'll just point the court to the two cases we cited on page 15 of our of our motion, where the Supreme Court said if a specific statute says only A can sue and not B, reading the APA to allow B to sue would undermine the purpose of that channeling scheme. The same thing goes here. I'm happy to address any questions, but can I just mention one thing, Your Honor? It's not really an argument, but I just want the court to be aware, because the NIH case that is cited, we did file a request for Supreme Court review of the NIH to be briefed by Monday. So if the court were inclined to wait, we're not going to.
We're aware of the status of the briefing. We're aware of the status of the briefing. Thank you, counsel. But you are now 5 minutes in, so I'll wrap it up there unless either one of my colleagues has any additional questions.
No.
All right. Thank you both so very much for this argument. We'll take the matter under advisement and get a decision just as soon as we can. We'll be in recess.
Hear ye, hear ye. All persons having had business with the Honorable, the United States Court of Appeals for the Ninth Circuit will now depart for this court, for this session now stands adjourned.